2002, several insurance companies that provided malpractice in this state raised their rates. It was unreachable for us. Several other companies stopped writing malpractice insurance. It became an immediate access issue. Other OBGYNs within our department, about 3 or 4, left the state. They couldn't continue to practice in the climate for several reasons, but the bottom line is they were gone. I hope common sense prevails, common sense which will benefit all our patients, and every person. As this gentleman said, we're all going to be patients. It's not about doctors, us versus them, lawyers. We're all going to be patients. And if there's restriction of care because of legislation that won't help anybody but maybe some self-serving attorneys, then that's the wrong thing to do. So I'd really plead with everybody to look to say, what is the right thing to do? It's all staring us in the face. And let's not have a return to these dark ages where we had to worry about things that had nothing to do with helping each other and taking care of each other.
We're back. We've been talking about a proposed rule change in the state Supreme Court that would give plaintiffs the option of venue shopping, which could drive physicians out of Pennsylvania. So now we're going to turn our attention to how this could impact access to your doctor and the healthcare coverage you get at work. We're joined by David N. Taylor, the President and Chief Executive Officer of the Pennsylvania Manufacturers Association. Nancy Albright is the Vice President of Underwriting at Medical Mutual Insurance Company of North Carolina. And William Mundy, an attorney and co-chair of the healthcare group at Burns White in Philadelphia. So Dave, let me start with you.
Yes.
What concerns you about this proposed rule change and how it might impact the businesses you represent?
Well, I mean, of course, first of all, yes, employers as the payors, that we're always concerned about rising costs, especially when it's not associated with any kind of increase in service or value. There's also a very big challenge with the workforce, with finding people, the qualified new hires to staff open positions. And so, obviously, if there comes to be a medical malpractice crisis where doctors can't get insurance, where doctors are leaving Pennsylvania, taking early retirement, makes it harder to have access to health care, that's going to make it more difficult for employers to recruit. But the thing that disturbs me most of all is the change itself, the reasons for the change, and what that says about the overall problem of lawsuit abuse in Pennsylvania. I mean, Pennsylvania suffers from a very expensive court system. Again, no one is saying that the cost should be zero. We need the courts to uphold the law and to enforce contracts to protect our rights. But the United States has a legal system that costs a full 2% of our gross national product. None of our international competitors have a system that costs even as much as 1%. And Pennsylvania, as opposed to our other states, has a worse problem with lawsuit abuse. And the fact that we got to a crisis in 2002, that this reform became necessary to say that for medical cases that it must be heard in the county where the harm is alleged to have occurred, rather than taking it to the most permissive jurisdiction to get the biggest award. That's an important reform, that would be reversed for no reason, when in fact that rule has been proven to work, that the filings in the county of Philadelphia are down, that the rates for the cost of coverage have leveled off and are more affordable for doctors. This reform has worked. If anything, this is a reform that should be enacted across the board, because of course outside of the medical realm, all of the rest of the economy, they have venue shopping, and that we have to fight cases that are filed in Philadelphia, regardless of how tangential the relationship is to the harm that is alleged to have occurred. So, I mean, the litigation industry is large, it's powerful, it's an enemy of the entire productive sector, and this, to me, it seems to be the opening salvo of a wider war.
Bill, speaking of the litigation industry, when the state put venue restrictions in place back in 2002, what problem did it solve?
Well, the primary problem was the nature and expanse of the rule that's in place, and something Dave was just mentioning, how it applies across the board. And what it does was it allows for definite areas in which the litigation could take place. For instance, if you had a malpractice claim arise in, say, Chester County, well, that's where it would be. So there's certainty to it. But the wider rule that is looked to go back to, that particular rule allows for much more ambiguity and much more allowance to make arguments as to why other counties might apply. So what it essentially does is it creates opportunities to move the case around or file in different, what might be considered more friendly venues. And it also increases what I like to call as procedural litigation. In other words, it has nothing to do per se with the actual merits of the litigation, but you start arguing about whether you have enough contacts or sufficient contacts in order to drag something into a forum that might not really have anything to do with the litigation itself. And that's, I guess euphemistically, has been called forum shopping.
So is placing venue restrictions on a case fair?
Well, I don't know why it wouldn't be fair. Frankly, I think the fair rule would be to expand it to everyone. And basically what the rule says now is if the action or the malpractice for providers occurred in a certain county, that county has an interest in it. And frankly, the defendant should be expected to, if something went wrong or there was negligence, then there's an expectation that you would probably be sued there. I mean, so for both sides, it makes a lot of sense. And it's a very cut rule. So you don't have a lot of this argument over where it should be. That's where it should be. So, you know, from that perspective, it's very fair. It's fair to both sides. And it doesn't limit litigation. What it does is simply give certainty to litigation. If you have a legitimate claim, you simply bring it in that county where it occurred. Very simple.
Nancy, you've been in the insurance industry for over 30 years. Take us back to what life was like in Pennsylvania before the 2002 reforms were enacted. What was the insurance climate in Pennsylvania back then?
It was bad. We had a lot of physicians who were seeing rates double, triple, depending on their specialties. The rates were sometimes to the point that the physicians couldn't afford them. They were closing up their practices. They were being absorbed by larger hospital systems. Patients' access to the care was limited. We had doctors pulling out of the states. Hospitals and physician offices had tough times recruiting. So the retention of quality doctors was not there.
Well, and I would like to add that, I mean, Pennsylvania is the most rural state in America, meaning we have the largest number of people who live in small towns and villages and farmsteads. And the quality and the access to health care in the rural parts of the Commonwealth is already a very challenging situation. So the idea that the courts would reverse this reform, make a bad situation worse, to me is just absolutely unconscionable.
It's actually a cost issue, too. I mean, it's funny that we have a national debate going on about the cost of quality health care, and everyone is concerned about that. Well, what you're hearing from Nancy and what you will see in the litigation is it will be a driver of costs, not a driver of reform that reduces costs. Because what will happen is the insurance rates go up, it's a business expense to the provider must deal with it, either by passing it on or some type of reimbursement, which automatically would increase it. So litigation costs would also increase, obviously, because of what I had talked about earlier, procedural type of litigation, but also because the drive to put it in venues that might be seen as more friendly and more willing to award larger amounts will also drive the cost from the insurance perspective as well.
It's very challenging also from the carrier side of things to rate a physician without knowing where the potential claim or suit could be filed. We could have somebody in a rural area with a doctor who's not paying a Philadelphia rate, and somehow that suit could end up in that Philadelphia court system. So carriers are going to have to reevaluate their rates, maybe file for increases in certain areas to try to compensate for this potential change.
And one of the trends that was happening, you know, at the turn of the century that was driving the need for this reform was the consolidation of health hospitals and health systems, and you know, the deployment of new technologies, telemedicine, these kinds of things. Well, those practices have only accelerated in the 17 years since, to the point where it was noted that that Lancaster General Hospital in the city of Lancaster is part of the University of Pennsylvania health system, which means that if this reform were to be scuttled, that it would be very easy for basically every case from Lancaster County to be taken into the jurisdiction in Philadelphia and put at risk of a jackpot award.
So what, you mentioned larger healthcare systems. What do you think the domino effect of this kind of rule change might have on some of the larger healthcare systems in Pennsylvania? One, you know, there's a couple in the east and a couple in the west.
Well, I mean, even though the consolidations have attempted to achieve economies of scale, that can only go so far, and so you would wind up with, I don't know what else to call it, but a default kind of rationing. Because, you know, again, the practice of medicine is voluntary. We cannot compel our physicians to practice medicine here as opposed to somewhere else. And listening to the young man from the previous panel, I think that our medical professionals are more conscious of the duration of their careers, because, you know, to be a doctor, you have to front load your life with so much schooling and residency and training and debt that you wind up focusing more on, well, how long am I going to be able to practice medicine? How long will I be able to make a living doing what I do? And so as a result, they're more conscious of things like, you know, the margin that they have with how much insurance is cost and whatnot. I think they're more tuned in to that opportunity cost. And so, you know, those skills are highly portable and always in demand. And so if you have the chance to go to Florida or Texas or someplace else, you're likelier to go there. I mean, and again, it's something that we do to ourselves. It's a tragedy. It doesn't need to be this way.
What's this going to mean for employees, employer-sponsored health care?
Well, I mean, we'll bear the burden because, you know, there's no choice. Obviously, you know, Americans are expecting to be able to receive their health benefits through their employer whenever those costs go up. You know, inevitably, you have increases in co-pays and those kinds of things. But again, if there aren't enough specialists, if there aren't enough physicians, if the maternity ward in the hospital closest to you has closed, there's nothing the employer can do about that. We'll pay the bill, but ultimately this is going to be a crisis of access to care.
Bill, we've got a couple of minutes left. What advice would you give, legal advice, would you give to hospitals or large physician groups should something like this become a reality?
I'm not sure I can give legal advice to somebody who's not a client, but I will simply bring up the point that you have to look at your contacts, and you have to look at your contacts across the state and where those contacts are, because as Dave brought up, those will now be litigation issues. Where it stands now, if you practice medicine, whether you're an institution or whether you happen to be an individual, you practice medicine in a certain county, there's an expectation that if you do something wrong, that's where a lawsuit will be brought. That's not anymore. You're going to have a lot more litigation over whether you have contacts with far-reaching counties and whether you can be drug in there. So those are the types of things you'll need to look at, and then prepare for the ultimate litigation that'll ensue in those other counties.
Nancy, use your crystal ball. What is the insurance industry likely to do in response to this rule change if it happens?
Well, first of all, you're going to see carriers filing for rate increases. It's inevitable. They're going to have to be able to rate the risk pending where they think these suits may come in. So their rate increases. It's going to have a trickle-down effect. The physicians are going to be paying the higher premiums. The patients are going to be, that's going to trickle down to their level as well with the higher co-pays and things like that.
Well, unfortunately, we're going to have to leave it there because we're just out of time. But I want to thank all three of you for joining us for this really important discussion. Nancy Albright, Bill Munday, and David Taylor from the Pennsylvania Manufacturers Association. Well, that's it for all of us. So now it's your turn. The last word on this proposed rule change comes from you. The public comment period on Rule 1006 ends on Friday, February 22nd. So there's still time to speak out on this issue and let lawmakers in Harrisburg know what you think You can share your thoughts on this by simply going to the Pennsylvania Medical Society website and write your views in the message box. Every voice matters if we're going to keep physicians here in Pennsylvania and ensure your access to quality health care for years to come. But time is running out, so don't delay. Until then, for the Pennsylvania Medical Society, I'm Bob Oltmans. Thanks for joining us.